Welcome to the Calmore Policy Center Candidate Forum. I'm Richard Nelson, Executive Director, and with me on this edition is Shea Nickell, Kentucky Court of Appeals Justice, and also candidate for State Supreme Court District 1. Shea, welcome to the program.
Thank you, Richard. It's such a pleasure for me to be here with you today. Thank you for this opportunity.
Well, you're very welcome. This is an opportunity really for the voters to get to know the candidates running for this. Of course, Shea is from the Paducah area, currently practicing. You are on the Kentucky Court of Appeals, have been there for a dozen years? 13 years. Mm-hmm. And you have an opponent in this race. Whitney Westerfield, state senator from Hopkinsville, is also on the ballot. But this is a chance for the viewers and the voters to get to know something about the candidates. And Shea, the first thing that comes to mind is, first of all, full disclosure, I've known you for years before you were elected to the Court of Appeals. And we actually worked together on an issue when you were the assistant county attorney?
Yes, for McCracken County.
So just wanted to get that out there. And I appreciate working with you, appreciate one of the things is your professionalism while the assistant county attorney for McCracken County, but then also on the Court of Appeals.
Yeah, I would like to just point out, too, in that respect, because you jogged my memory, I had forgotten that, but that involved the McCracken County sexually oriented business regulations, right, which we took to the Kentucky Supreme Court and had it upheld. So we were successful there.
That's right. And it's always good to have a victory when it comes to improving community standards.
Yes.
So here's my question. I want to start out with this. Tell us a little bit about your background, just very briefly. Education, family, and where I want to go is you are a Kentucky Court of Appeals justice. Why would you want to, you're in a comfortable position, if you will, why would you want to run for the state Supreme Court? But first of all, a little bit about your background, if you would.
Sure. I'm a native of Paducah, Kentucky, down in McCracken County. My parents were both very active in church. My mother was a church organist and choir director for over 64 years. My father was a very active lay leader in the Methodist Church. And so I was brought up in church. I do a little singing because of my mother's influence, obviously. Then I went to a little school in Greencastle, Indiana, a Methodist school, DePaul University, and obtained my undergraduate degree in political science and communications. Then I came back to the University of Kentucky, where I obtained my law degree. Started out practicing law in eastern Kentucky at a regional firm down there, a small regional firm. And we represented clients including the local hospital, local bank, savings and loan, realtors. Did some plaintiffs' work. In a small rural regional law firm, you do a little bit of everything. Mm-hmm. From there, I went down to North Carolina. I taught jurisprudence for a while there at the University of North Carolina at Chapel Hill, then returned to Kentucky, to Paducah, and worked in one of the premier insurance defense firms here in Kentucky, Bell, Stouffer, and Graves, and then was recruited to work at one of the plaintiffs' firms, Saladino Law Firm, before establishing my own law practice, the Nickell Law Firm, where I did a lot of workers' compensation representation and also social security. At that time, I also taught at Murray State University, insurance and risk management. And my old high school friend, who was the county attorney, hired me as his assistant. That's where we met. Yeah. And so I was with him for a number of years, doing the full gamut of types of cases that you would expect a county attorney to handle. So that's pretty much my practice before becoming a judge 13 years ago. And when I became a judge 13 years ago, 2006, of course, you and I had developed a friendship at that point, but I was particularly proud at that time to have the endorsement recommendation of the Kentucky Right to Life organization, and also the public endorsement of my old friend, the late Dr. Jerry Falwell, and Matt Staver, who was the dean of the law school there at Liberty University at the time, and of course now continues at Liberty Counsel. So I was elected to the bench, the appellate bench, 13 years ago, and since that time have developed a record.
So, and those are quite impressive endorsements from nationally known figures. So why, getting to what I was getting to earlier, why would somebody, again, you're very successful in the practice of law. You've been on the Court of Appeals for 2 terms. You're in your 3rd term?
In my 2nd term.
In your 2nd term. So why are you running for the state Supreme Court?
You know, that's a question that has come up often during this election, and it has caused me to reflect a great deal. And I think I aspire to the Supreme Court for the same reason that I became an attorney in the first place. And looking back to my youth, I always held 2 professions up in the highest regard. One was the pastors of my churches. Had great respect there. And then also in looking around the congregation, I saw the attorneys and the impact, the positive impact that they had on our communities. And I think like everybody else, I wanted to be a part of something larger than I was. I wanted to leave this world a little bit better than I found it. And I felt like either of those professions would allow me that opportunity. So I struggled for a time with which route to go. And ultimately, I discovered that one could have a ministry within the law. And that's what I've tried to do, either as a practicing attorney for 22 years or as an appellate judge for the past 13. I see each decision as part of a much broader picture.
It's interesting that you put it that way, Shea, that you see the law as an opportunity for ministry, and I don't know how many people see that. And I guess you could probably expand it to go beyond just the legal profession, where if you saw other, whether it's teaching or business,
Yes.
Other areas of calling that could be viewed as a ministry area as well. So I want to get back to your candidacy for the state Supreme Court. What are some of the traits that the voters should look for in a Supreme Court candidate or a good Supreme Court justice? What are some of the qualities that would make for a good candidate?
Well, I go back to my Boy Scout days. I'm an Eagle Scout, and I remember that we're taught to be prepared. And so I think when you aspire to the highest court in the land, that you should have a record that demonstrates that you have attempted to be as prepared as you can for the important role and responsibilities at the Kentucky Supreme Court. And I think if you look at my record, if you've looked at my decisions and how I've worked with colleagues in not just reaching opinions, but also administration of the courts, I've tried to prepare myself. If you look at my record in particular, I have sat as an associate or presiding judge in over 2,800 opinions in 13 years. Of those, I have authored the opinion in over 965 appeals. And of those that I have authored, only 21 or 2% have been set aside in whole or part. And I don't say that to brag, but what I say that for is to indicate to the voters that I have a record. I have a record that tells the voters that when I say that I believe in the rule of law, that I believe in judicial restraint and judicial independence, that I've actually lived that out in the way that I've approached cases coming before me. I am not a judicial activist. I do not legislate from the bench. As U.S. Justice Gorsuch said, I think in an interview recently, I understand that a judge is not a politician in a robe. We're there to interpret fairly the law and apply it to the facts before us.
And I appreciate you laying that out. That was actually my next question, Shea, was what is your judicial philosophy? And I think you shared in those 3 points that you're not an activist judge, but you believe in the rule of law, you believe in judicial restraint, and you believe in the independence of the courts or the
Yes.
judiciary. Could you tell us what is I want to go with that first point, the rule of law. What does that mean? How do you understand that?
Well, I think the modern terminology that you hear a lot these days is that one is a constitutional conservative. I think what that really is descriptive of is some older terms that were made most popular by the late Justice Scalia of the U.S. Supreme Court, and that is one who is a textualist, an originalist. Someone, and by that I mean someone who goes back to the Constitution or the law and attempts to discern what the intent of the drafters were, and to apply that intent, and also to give words their common meaning, their plain meaning, and not to try to read into the language some modern agenda, but to go back to the original intent and meaning. And I heard an interview with Justice Gorsuch just recently where he referenced that, and I was impressed by the fact that he underscored that if a change in the law or the Constitution needs to be made, that we, the people, can make that change. It's not for judges or justices to make that change, but there are processes and procedures whereby we can change the Constitution or we can change the law. And there are rules that we have to follow to do that. And those rules are not just to be onerous, but they're to cause us to slow down and intentionally study a matter before we make any major change, to try to discern what the unforeseen unforeseen consequences would be
Certainly.
of a law.
So, and that's good. I appreciate you sharing that. What is related to your judicial philosophy? And you kind of touched on this. What do you think is the proper role of the courts? And when I say that, I'm talking about the courts in general. I think, Shea, that there's a mindset with a number of people, at least with part of the political spectrum, that sees the courts as being judicial activists, overstepping the role of the courts in a way where the courts are making the laws. I heard there's a famous story of, I can't remember the person it was, but some political figure in Washington, D.C. that was giving a tour of all of the big buildings, and they were in the, well, here's the FBI, they take care of executing the laws and serving warrants and that kind of thing. Well, and then here's Congress, and here's the White House, and then they go by the Supreme Court, and this person said, and here, ladies and gentlemen, here's where your laws are made. But, so all joking aside, there is a perception that the courts have overstepped and they're assuming a role of a super legislature, if you will. Mm-hmm. And so what is your philosophy, or what are your thoughts on the proper role of the courts?
Well, as my record as an appellate judge indicates, I have tried to adjudicate and not advocate. Advocacy.
So if I could stop you,
yes.
So adjudicate, what does that mean for the layperson?
Yes, one who adjudicates is one who takes the law or the Constitution as it is given and tries to interpret it honestly and fairly, and then to apply it honestly and fairly to the facts as are presented in an appeal to reach a just decision. And I think what the voters need to understand, too, is that appellate judges can only take the facts as they are presented to us from the trial record. If there are outside facts that were not placed in the record, we cannot consider those. We have to focus just on the record before us. So to adjudicate, and that's my skill set. That's what I have done for 13 years for the people. There are other important roles in the other two branches, the legislature and the executive branch, but they tend to be more of the advocates, and that certainly takes a skill set too. But I have focused my professional life on developing the skill sets that are called for that is called for to be an adjudicator, one who can fairly take the law and apply it. And that's the other thing I would point out to voters, Richard, is, and I believe it was the late Justice Scalia who said this, and before him Justice Robert Jackson, that if an appellate judge has not written an opinion with which they totally disagree, that they're not much of a judge. That if you really are committed to following the law and applying it to the facts as presented, there will be occasions when you will have to rule contrary to your own personal perspective, your own preferences. But that's what a judge is called to do.
Sure. Could you, so I want to put out a controversial ruling, since we're talking about rulings that judges might disagree, have a personal opinion, but they're trying to follow the law. One of the most controversial rulings in my lifetime was the Obergefell decision from just a few years ago. This is where the U.S. Supreme Court overturned all the state marriage amendments, including Kentucky's. And a couple of parts in this question. One is, was that based on law? Was there legal precedent? Was there legal tradition that they applied to in that case in arriving at that conclusion? Because we're talking about the rule of law. We started out with that, and we're talking about adjudicating and applying the law to the facts that are at hand. And the Obergefell, of course, was very controversial. It was a 5-4 ruling. There were 31 states that had amendments to their constitution that defined marriage as being between a man and a woman. And when the U.S. Supreme Court overturned those state constitutional amendments, I think a lot of people, including myself, felt like the process was short-circuited. Those who went through the steps of amending a state constitution, first of all, the legislature was to take action. You had to have a supermajority in the House and in the Senate, and then it went to the ballot for the people to decide. So it was a lengthy process. And, of course, the court ruled in a very narrow ruling, and they said that, we're putting that aside, that we have the new definition of marriage. What are your thoughts on that?
Well, as you indicated, I certainly have my own personal views on it, which I think should be fairly clear based on my background. And certainly I don't want to go too far afield in commenting on something that may come back in front of the courts. Certainly I think there's some thought that there will be more decisions sent back to the states to make, given our current federal Supreme Court's makeup. So with all that said, however, I would just say that though I describe myself as one who practices judicial restraint, there are judges who are known as judicial activists. And that doesn't mean that they're not necessarily bad people or anything like that. But it does mean that they have a different view of what it means to be a judge or a justice. Their view would be that the law should evolve, if you will, based on changing public and social attitudes, and that judges should be free to consider those when they're interpreting and applying the law. I do not hold to that, but there are those who do, and there are those that would certainly argue that the case that you've referred to is a prime example of that. But then to echo Justice Gorsuch from his interview last week or two, I would say that ultimately the power is with the people. That through constitutional amendment and through continued challenges, that this is an issue that most likely we've not heard the last of.
Let's talk about that further. You said the power resides in the people, essentially, and that comes from the Declaration of Independence. that idea that governed by the consent of the governed, which is a very interesting phrase that you find there. But what role, I want to kind of flesh this out, what role do the people have in making the laws? Of course, we had our founding fathers that came together. They were the representatives of the people. They crafted our political documents, the Declaration and the Constitution. But what role today do people have in making the laws? How does that look?
Well, I think with any responsibility or role, as you reference it, there again has to be preparation. I think the public, the voters, need to be informed. They need to educate themselves on the issues. In law, I have learned that you don't take one particular study at face value. You have to study the studies sometimes and see what the methodology was or the data that went into the results are before you accept it. Don't be so accepting. Verify, if you will, as President Reagan used to say. And then to be involved in the process as your organization and others like it, to let your voices be heard, connect with your legislators. And again, legislature, your executive branch, that's where the policy decisions are addressed. Once a matter comes, at least from my view, once a matter comes before the court, it should be adjudicated fairly under the rule of law, judicial restraint. Am I conservative? Anyone who knows me, ask my friends. Am I a Christian, a professed Christian who tries to best to live according to the gospel? Yes. And really, there's not a lot of difference between myself and my opponent in that respect. We're both conservative. We're both Christians. He likes to point out that he's a member of the Republican Party. Of course, this is a nonpartisan race constitutionally, but quite frankly, we're both members of the same party. So that's really a non-issue as well. I think what this election comes down to for the voters is deciding who has the most experience as a judge, an appellate judge, and the most experience with the law. I bring 35 years as an attorney, 13 years as an appellate judge. Wow. I think that experience is unmatched, and that's what I would like to take to the Supreme Court. I'll be pleased to stay at the Court of Appeals and serve the people there, but I believe that God has given me this opportunity to gain this experience so that perhaps there might be something more I can do on the higher court.
I understand. There are a couple of high-profile issues that have come before the state Supreme Court. One is expanded gambling. There was a ruling handed down recently. I think they remanded it to a lower court. But the issue of instant racing, Shea, has been a hot issue for about 10 years, where essentially the Kentucky Horse Racing Commission unilaterally decided that instant racing machines really aren't video slot machines. It's really not expanded gambling, and therefore we're going to allow the existing horse tracks, to bring these machines in. Now, if you've not seen an instant racing machine, it essentially looks like a video slot machine. We won't go into the details, but that is one issue that I'm not sure if it'll come back to the state Supreme Court, but it may. Gambling expansion is an issue of concern to the Commonwealth Policy Center. Another issue I want to put out there is the religious freedom issue and free speech rights of citizens. Blaine Adamson owns a T-shirt company. He's a graphic artist in Lexington, and he was asked to print a message on T-shirts to fill a large T-shirt order with a message that he disagreed with. Now, Blaine has won at a couple of lower courts. Actually, that was in front of the Court of Appeals. I understand that you weren't on that case, though. There was a limited number of judges that were on that panel. But he did bring his case to the state Supreme Court, and they're going to hand down a ruling at some point. But those are two issues I'm wondering if you feel comfortable commenting on. Gambling expansion that has kind of circumvented the process, and then also First Amendment freedoms of business owners. I say, and I'm putting those issues out there gently, if you will, because I realize that as judicial candidates, if you get too far into the weeds on certain issues, if you stake out a firm position, you might have to recuse yourself if those issues came up before
Yes.
you in a
Yes.
case. Correct.
Yeah. Yeah, and let me say, in answer to that, that I am a classical, traditional conservative, if you will. I believe in the First Amendment. I certainly believe in the Second Amendment. I'm a member of the NRA, anti-gambling as well. But again, I would say to the voters that when I put on the robe and go into the courtroom, I have to take off what my personal views are and to determine any case based on what's presented to me. Mm-hmm. And in America, this land that we love, everyone is entitled to feel that they've had a fair shake, that their arguments have been fairly heard before the tribunal, before a decision is reached. And that's what I try to give everybody, a fair shake under the law. And so, again, in answer to your question, a lot of those are policy issues that will require some legislation. That legislation ultimately will end up in the courts, so I have to limit myself on my comments on it. But when they do, everyone, all parties, all sides can rest assured that this is one judge, this is one justice who will fairly and honestly interpret the Constitution and the law and apply it to the facts as presented.
Very good. So, Shea, we've got just about a minute here, and I'd like you to wrap it up and tell the voters why they should vote for you as a candidate for the Kentucky State Supreme Court District 1, which, by the way, that covers the Purchase area, so Paducah, Murray, Mayfield, Hopkinsville, Madisonville, Henderson. How far further east does that district go? What are we looking at?
Well, I can drive 3 hours and be in my district. So there's 24 counties in the first district, and you're correct. It reaches all the way from the river counties up to Hopkins County, Webster County, that area, and then down, wraps around Warren County, doesn't go into Bowling Green, but then hits the southern counties along the southern border as well. So it's a large area.
So large area. Tell the voters, we got 30 seconds, I think. Tell them why they should vote for you.
Again, I have been an appellate judge for 13 years. I have a record. I don't just give you rhetoric. I give a proven record that I follow the law, that I practice judicial restraint. You know who I am. I will be the same type of justice as I have been a judge. And I hope that I have made you proud. I appreciate your trust. And whether I continue to serve you on the Court of Appeals or at the Supreme Court level, I promise you that I will continue to give my very best each day and to be the type of judge that will make you proud.
All right, Shea Nickell, thank you for joining us on the program. And thank you for tuning in to this special presentation by the Commonwealth Policy Center. Hi, I'm Richard Nelson with the Commonwealth Policy Center. You can find more of our videos on YouTube and Vimeo. And for more information about the Commonwealth Policy Center, go to our website, commonwealthpolicycenter.org.